If you get divorced after receiving your 10-year green card, don't worry. Congratulations, you still keep your 10-year green card. The 10-year green card is considered permanent residency, so your status won't change just because of a divorce. In 5 years, from the date you received your 10-year green card, you can apply for naturalization to become a U.S. citizen. This is true whether you're still married or divorced. There's no law that requires you to remain in an unhappy marriage indefinitely. You can move on with your life and still pursue citizenship. However, when you apply for naturalization, be prepared for some questions. During the naturalization process, U.S. Citizenship and Immigration Services, USCIS, will likely ask about the bona fides of your marriage. This means they will want to verify that when you initially received your green card, your marriage was real and not entered into solely for immigration purposes. They'll be looking for evidence that your marriage was based on a genuine relationship, not just for the benefit of obtaining a green card. This is particularly important because the government wants to ensure that individuals don't use marriage solely as a tool to gain immigration benefits. USCIS may ask about how long you were married, where you lived, and if you shared finances or lived together during your marriage. But remember, just because your marriage was genuine when you received your green card doesn't mean you have to stay in that marriage forever. Divorce is legally acceptable, and your 10-year green card remains valid even if you divorce. If you were granted a green card based on a marriage to a U.S. citizen and then divorced before your 10-year green card was issued, there may be additional considerations. You might need to submit additional proof of the validity of your marriage when applying for the 10-year green card. However, once the 10-year card is issued, you're in the clear, and divorce won't affect your residency status. When you apply for naturalization, it's also important to note that you can file for citizenship even if you've been divorced, provided you meet the other eligibility requirements, like continuous residence in the U.S. and good moral character. So, while a divorce may raise some questions during the naturalization process, it won't prevent you from becoming a U.S. citizen as long as your original marriage was legitimate and your intent was to build a life with your spouse at the time you received your green card. Ultimately, staying in an unhappy marriage isn't a requirement for maintaining your immigration status, but ensuring your original green card application was legitimate is key to moving forward with your naturalization process.